Good evening, everybody.
Hello.
Some logistics before we get started. If you've got any questions as we go along, there's a Q&A box, so feel free to put them in there, and we will either get back to you on those at the end if we've got enough time, or if not, we'll send you a quick email about them. If you're watching this recording after today, please feel free to send any questions to our email address, which is events@42br.com. An email containing this recording and a feedback form will be sent around over the next few days, and it will also be available on our website and our YouTube channel.
Thank you for that, Eleanor. Let's introduce ourselves properly now, shall we?
Of course.
My name is Iris Ferber Casey, and I'm a specialist employment barrister at 42BR Barristers.
And I'm Eleanor Wheeler, also an employment lawyer here at 42BR.
This is the fourth and final webinar in our 2024 employment law series, and we're going to be discussing, are we not, Eleanor, the strange and troublesome world of holiday pay.
We know you're all excited.
We're all very excited about it. Now, let's start with a caveat. It is very much an introduction, and it is very much only the law as it is on the 3rd of December 2024, because holiday pay law changes all the time.
It's quite a fast-paced area.
It is. Be aware.
So we're going to be covering some headline topics for you, as Iris says, in a fairly introductory, light touch way. First of all, who has the right to holiday pay? Secondly, what are those rights? Thirdly, how is the amount of holiday pay calculated? Fourth, how do we enforce those rights? And fifth, what are the time limits that apply?
Shall we get started?
Let's dive in.
Okay. First question. Who has the right to holiday pay? Well, the answer is a worker has the right. Easy.
Let's
move on to the next thing. No, it's not that easy. Okay. A worker is actually rather a complicated topic, probably deserving of an entire hour's webinar on its own. Let's not do that. Let's do a bit of a light touch introduction to what a worker is. Regulation 2 of the Working Time Regulations 1998.
Those are going to be our key regulations.
Those are our key regulations for much of what we're going to be discussing.
Yeah.
And Regulation 2 defines a worker. Definition is identical to what you find in Section 230 of the Employment Rights Act, your favourite section, I know, of the Employment Rights Act.
I read it daily.
Yeah. Also, same as the definition in the National Minimum Wage Act. And we know that the definition of worker includes employees, but it's wider than that, don't we? And we sometimes call that the Lim B as opposed to the Lim A definition. So for the purpose of this introductory session, let's just start with what the wording of the regulation is.
The boring bit.
And the boring bit, and then we'll see what that means. Okay. So Regulation 2, brackets 1. It's an individual who has entered into or works under or used to work under a contract of employment, that's Lim A, that's the easy bit, or Lim B, any other contract, whether express or implied, if express, whether oral or in writing, whereby the individual undertakes to do or perform personally any work or services for another party to the contract, whose status is not by virtue of the contract that of a client or customer of any professional business undertaken carried on by the individual.
Quite wordy. What does that actually mean?
In practice, a worker, if they assert that they are a worker, has to show, 1, the existence of a contract, 2, that he or she undertakes to personally perform work for another party, and thirdly, that the other party isn't a client of a professional or a customer of a business undertaking that's being carried on by the individual. So I don't know if that's easier. Maybe that isn't much easier than just reading out the definition. So Eleanor, can you give us some examples? That might help.
I can. So we're talking here about agency workers, freelancers, casual workers. It's probably actually easier to define what isn't a worker, because that's a narrower category. So volunteers are not workers. Self-employed people are not workers. So if you're genuinely pursuing a profession or a business activity in your own right, you are not a worker. Other than that, you probably are.
And then you have holiday pay rights.
Exactly.
Okay.
So
So
what are those rights? That's the next topic.
Cheers.
There are three main regulations at play here. You don't need to know all the regulations by heart, but you probably do need to know these ones if you're going to be in the tribunal about this. So, first one, Regulation 13 and 13A. That's the right to take leave, and leave is split into two types, basic leave and additional leave. And we'll go on in a second to talk about what those are. Regulation 14, that's your right to receive your payment in lieu of unused holiday if your contract is terminated. So you could resign, you could be dismissed. If you've got outstanding holiday at that point, you have the right to be paid for it.
Yeah.
And then the third regulation, the key one, Regulation 16, is pretty simple. It's just the right to be paid while you're on holiday.
Okay, well, I've got quite a lot of questions about that. Let's start with this one. How much holiday is basic leave?
So basic leave is 4 weeks,
Yeah.
simple enough,
Okay.
per holiday year. That is a 12-month rolling period. It'll start on a particular date. It's usually defined in the contract. Most employers use calendar years, but they don't have to. They can pick whatever date they like, but it's a 12-month period running from whenever is stipulated in the contract.
Okay, so 4 weeks a year, starting with whatever the first day of the rolling holiday year is. That sounds
Exactly.
really simple. Why do people get so worried about it?
So easy, right?
Easy.
Okay, this is why it's complicated.
Mm.
It depends on how much work you do in 1 week.
Mm.
So the amount of holiday for someone who works full-time, 5 days a week, is going to be different to the amount of holiday that someone who works 1 shift a week would be entitled to.
Okay, I see. So the definition of how much holiday there is in 1 week depends on how much work you do when you're not on holiday.
Yeah,
Okay, gotcha.
Exactly.
So what about additional leave? Does that work in the same way?
sort of, yeah. But it's 1.6 weeks.
1.6
1.6
A
weeks.
fraction of a week.
A normal amount of a week, sure. Yeah.
Why? That just sounds really complicated.
It does sound complicated.
There's probably a philosophical answer to that.
There may well
Why
be,
question.
but I'm not going to get into that.
Mhm.
So the only thing we need to know is the total you're entitled to is 5.6 weeks a year.
So 4 weeks plus 1.6 weeks.
Exactly. 4 weeks
Okay.
basic, 1.6 additional.
Right.
And the actual amount of holiday that translates into depends on how many hours per week you actually work.
So, okay, I think quick calculation, pretend to do a quick calculation. If I work full time, 5.6 weeks, 28 days holiday,
Yeah,
right?
straightforward.
Straightforward.
Nice.
Maybe that's why it's 5.6 weeks to make it 28
28
days.
days.
Okay. What about somebody that works 6 days a week? There are people who work more than full-time hours. Do they get more holiday than 28 days?
So sadly not.
Oh.
For those unfortunate souls, there is a cap, a statutory
Okay.
cap. So you only get 28 days of statutory holiday per year, even if you work more than 5 days per week.
That's the statutory rights. I suppose there could
Exactly.
always be contractual rights on top of that.
Absolutely.
Potentially.
Yeah.
Okay, so a few other things to mention then on top of that, those sort of basic points about a week's holiday. Number one, employer can they turn the holiday right into a payment in lieu?
No.
They can't convert a right to X number of days holidays per year into an extra payment. And that's because the purpose of the right to holiday isn't a financial right, it's a health and safety right. The intention is to ensure that employees actually take their holidays.
Exactly. So the only time that they're allowed to convert holiday into cash is after you've been terminated, and it's a pay in lieu of notice, the sort of pile-on payment that you might see on some pay slips.
And worth just highlighting, I mentioned about contractual entitlements above the statutory maximum of 28 days holiday per year. Actually, any contractual entitlement to holiday above basic and additional leave is entirely contractual. It's not statutory at all. So if the contract allows for a pay in lieu of holiday above your basic and additional rights, that might be possible. It just depends on whether the contract allows that or not.
You just have to look at the wording of that.
Okay.
So one thing that I know vexes a lot of employees is the concept of carryover. So whether you can carry over leave from one holiday year to the next.
seems complicated, doesn't it? That's because it is complicated, as is much in relation to holiday pay. Carryover is one of those things. What if the worker has not been able to take holiday or take their full entitlement to holiday in a particular holiday year? Is that year's holiday entitlement a use it or lose it right? Or does the right carry over, roll over, if you like, into the following year? As always, with any legal question, the answer is no, but. So what do I mean by that? You can't carry over holiday into the next holiday year. It's a no. You use it in the year or you lose it in the year. But there are some exceptions to that.
Yeah.
And broadly, those exceptions relate to situations where the worker is for some reason prevented, for reasons which are not their own fault, from taking their holiday in a particular holiday year. And there are 4 different types of exception. All of them relate to not being able to take a holiday. First one is if you're sick.
Fine,
so if you're sick in the year to the point where you are unable to take some of your holiday, that bit that you weren't able to take because of sickness
can
carry over into the next holiday year. If you are on maternity leave, equally you can carry over what you weren't able to take into the next year. If you are actually factually prevented by your employer from taking holiday, so Eleanor, I know you wanted to take those 4 weeks off, but you can't. We've got a big order coming in. You're going to need to work that time. I'm not letting you take that holiday. And you're not
having it next year.
You'll be having it next year. So actual prevention by the employer from taking your holiday. And then finally, the sort of Jack in the box, number 4 type of exception, which is the one that is most tricky in the real world, is that the one where the worker is not told that they have a use it or lose it right. So you can imagine lots of situations
that's going to trip some employers up.
It's going to trip employers up. If you have not told your workers, whether that's because you've not put it in a contract or there aren't any contracts and you haven't set it out in any other documents, if you've not told workers that if they don't take their holiday in the holiday year, then they're going to lose the right to that holiday, then that failure to provide that information makes the holiday carry over into the next year.
Because basically for an employee to have
it's something to check if you are a worker and you're considering your options in terms of carryover. Basically, it's to do with ignorance of your rights, isn't it? So in any of those circumstances, being sick, being on maternity leave, being actually prevented by the employer, or being ignorant because the employer hasn't told you that it's a use it or lose it right, in any of those circumstances, you can carry over holiday, but only into the next holiday year. You can't keep carrying the holiday over.
Just one chance only thing. Okay. So the next big topic, how is holiday pay calculated?
Looking forward to this. You're going to explain it to me.
Deep breath, everybody. This is not the easiest aspect of the law, but I'm hoping to be able to provide you with some common sense signposts to work out how this is calculated. So
that sounds very comforting.
I try. The unit for calculating holiday pay is a week's pay. Now, lots of people have to look at what a week's pay is for the purposes of working out other things in employment law. So your basic award, if it's an unfair dismissal claim, that sort of thing. And there are statutory rules, which we'll come into a moment in relation to a week's pay. First thing to remember, though, is a week's pay differs depending on whether we're dealing with basic leave or additional leave, just because they didn't want to make it easy for us.
Right. So in order to calculate the amount of holiday pay, you need to know whether you're taking basic or additional leave.
Absolutely.
Correctly.
We'll deal with basic leave first, because that's more complicated. And if you haven't switched off and gone home by that point, we'll deal with additional
I might
leave.
have done.
Sure, I'll just do it alone. So basic leave, a week's pay in accordance with this holiday pay arena of law is normal remuneration.
Are we putting that in inverted
normal
commas?
Remuneration.
Okay, that's the test.
That's the test.
Right.
It can include things like overtime, commission, allowances, bonuses. We're going to talk about all of those specifically in a moment. But the overarching principle is as long as those payments are normal, i.e., received on a regular basis and have some intrinsic link to the type of work that the worker is employed to do, they're likely to be regarded as normal remuneration for the purposes of working out the first 4 weeks, the basic leave entitlement.
Right.
So the starting point, as I've said, is the statutory test, which is sections 221 to 224 of the Employment Rights Act.
So as you were saying, that's the usual method for calculation, say, of a week's pay to calculate the basic reward.
Exactly.
All sorts of rights under the ERA
Exactly.
use this calculation method.
So we start with that,
Okay.
and then because of EU law, we modify it slightly.
So why should it be straightforward?
Why indeed? So
Okay.
these are the modifications you have to make to the normal section 221 to 224 rules. First of all, a very easy one, where you see any references to an employee, you just read worker. Second, the calculation date is the first day of the period of leave. So all of these calculations start to run or work back from the first day that you're expected to be on holiday.
Okay.
There's no statutory maximum when you're working out what a normal week's pay is, because you're supposed to be compensated for the actual pay you would receive if you were at work. Otherwise, there's really no incentive to take the holiday. You might as well be at work if there's a statutory maximum and you exceed that. And the other really important modification is that instead of a 12-week reference period, I'll talk about that in a second, it's a 52-week reference period. Now, the reference period is just the period over which you take an average to work out what a week's pay is. For a lot of calculations under the ERA, it's going to be 12 weeks. So if you're working out an unfair dismissal claim, that sort of thing, you're looking at 12 weeks. But the courts have realised that for a lot of people who do seasonal work, for example, that's not very fair because they're going to be paid much more in summer than in winter. And so 12 weeks might not be reflective of their overall pay for the year. So holiday pay gets a special allowance for a 52-week reference period.
What if the worker has been working for less than 52 weeks? What if they started that job 6 months ago?
Nice and straightforward. You just take an average of the number of weeks that they have actually been there, if it's less than 52.
And if they're doing summer work, that seems really unfair. So let's say you do 3 months work a year, you get paid whatever, but then what, you're averaging that over a year and you're sort of spreading that as if it was being paid to you over 12 months? That doesn't seem fair.
Yeah, so you're not doing that.
Okay.
You look back at the previous 52 weeks and you take an average of the 52 weeks. That applies for full-time, part-time, shift workers, people with variable hours. But if there are periods within the 52 weeks where you've received no pay at all, you're allowed to look back further in time and bring into the 52-week period other weeks where you were paid back in the past.
Week, I guess.
Earlier
You're working
weeks.
backwards from the date of the
Exactly.
proposed holiday.
The only thing I should say is there is a total backstop of 104 weeks. So you can't look back further than 2 years.
Okay.
If you look at a total period of 2 years and you can't actually find 52 weeks in which the worker was paid, you simply use the number of weeks in which they were paid something, even if it's lower than 52, in the same way as you would if you're dealing with a worker who's only been at the company for 3 months.
So I guess in a sense what you're doing is if you had a sort of calendar of every week backwards from your first day of your holiday, you're crossing through any week where there's no pay.
Exactly.
And then you're only averaging the weeks where there is some pay.
Until you can get to 52,
until you get to 52 weeks.
If you can. And if you can't, that's fine.
And I guess that's how you deal with a problem of calculating the pay of a variable hours worker.
Exactly.
If somebody is working the same hours every week, whether that's full-time, part-time or shifts, whatever it is, that it's not such a big deal. You're sort of averaging a number that is the same number in every week anyway.
Exactly.
But if it is variable, that's how you get to a number.
Yeah, and I think they've approached it in that way because it's just fairer to take an average over a long period and be able to sort of bring in earlier periods still.
It's a more accurate reflection of the remuneration.
Exactly.
Okay. Well, should we have a look then? You promised me discussion of overtime bonuses and all that lovely stuff. Let's look at what goes into the calculation. Obviously, salary goes in.
Sure.
Clearly. You talked about overtime. That's the first thing I remember you mentioning. Tell me a bit about how overtime calculation works. Then.
Yeah, so this is an interesting, in loose terms, aspect of holiday pay law. So the European courts have decided that it's not fair simply to pay people basic pay. They've got to be remunerated for the actual amount that they would take home if they were at work. So unlike a week's pay under the ERA, you can include overtime of all sorts. So under the ERA, the only type of overtime you can include in a week's pay are where it's obligatory. And by that I mean the employer is obliged to offer it and the employee is obliged to work it.
So it's more akin to normal hours, actually.
I don't even know why they call that overtime. That's just your job.
Yeah.
But that would be fine under the ERA. But if we're dealing with holiday pay, you get an added bonus that you can include any overtime of any variety, as long as there is a direct intrinsic link between the performance of your duties and that overtime payment.
So, I mean, I guess it comes back again to that phrase, normal remuneration.
Yeah, exactly. And there have been a lot of authorities looking at this. We're not going to be throwing many of them out to you. This is, as I say, an introductory talk. But if you're going to know any, you're probably going to want to know British Airways PLC and Williams and Lock and British Gas Trading Limited. Both of those are cases where this issue of overtime was discussed, and it was confirmed that if you normally get paid overtime as part of your week's pay, that can be included in a week's pay.
And commission was also one of the things that Lock and British Gas talked about, wasn't it? So a bit like overtime, similar sort of test. Is commission part of your normal remuneration, i.e., is it directly and intrinsically linked to your contractual duties? Yeah. So, for example, kind of easy example, but easy examples are good. We like easy examples. If you are paid commission on sales and you are a salesperson, then that commission is going to be intrinsically and directly linked to your duties. And that's the sort of commission that will be included in the calculation of holiday pay.
Absolutely. Right? Okay. Another thing that some types of workers might be involved in are standby payments and call-out payments. Now,
tell me a bit about those.
Those are, for example, doctors, people who work in fire stations. If you are on call, if you're on a sort of out of hours standby rota.
So I guess that comes from standing by, waiting to see if you're going to be called to go to work.
Exactly. Okay. So if you get the call, you have to make yourself available and be in, but you're not physically at the place that you work. Or if you get paid every time you in fact do attend a call out. So if you get sort of one-off payments every time you have to wake up at 2 a.m. to fix a plumbing disaster, those payments, standby payments and on-call payments and call-out payments can be included in your normal.
And both of those might arise in one employment or one.
They tend to be quite linked because the type of people who have to be on standby in the middle of the night for emergencies are also the type of people who expect to be paid if you do call them out for those emergencies. So they tend to come hand in hand.
Okay.
The right to recover those types of payments are set out in another case. Promise we're not going to give you too many, but this is Dudley, NBC and Willets.
Okay. And again, if I were doing a job and once in a blue moon I had to be called out, like once a year, if that's not going to be normal remuneration, because it still does come down, doesn't it, to normal remuneration
and regularity.
Yeah. But if I'm regularly on standby, regularly doing call outs, that's where I'm going to be able to say to my employer, or if I'm a worker, to the person who's giving me the work, that payment should be included in the calculation of my holiday pay.
Absolutely.
Okay. What about allowances? That's another one that does apply because of the European case law, doesn't it, to holiday pay. So what's an allowance? Some employers, some people providing work give additional allowances to reflect particular qualifications,
Sure.
additional allowances to reflect length of service sometimes,
Yeah.
or to reflect seniority in the role, as long as the allowance is personal to the individual worker, so that it forms, again, part of normal remuneration, then that allowance can be included in holiday pay calculations.
Similar, but treated very differently are expenses. So expenses do not form part of normal remuneration.
Okay.
Expenses would be defined as payments purely to cover occasional costs. So we're talking travel expenses or subsistence while you're away, staying in hotels. There's a case called British Airways and Williams, which we've referred to already, which says that is not part of normal remuneration. That's a sort of as and when type payment.
And it's only to recover, presumably, money that you've had to pay out.
Yeah.
So I've paid for a taxi from the airport to the hotel, I'm getting that money back.
Exactly. Okay. Sure.
What about bonuses? Bonuses are tricky and very, very fact specific, aren't they? So again, repeat that test. Is the bonus intrinsically linked to the performance of tasks by the worker under the contract?
Yeah.
For example, a bonus that relates to my performance as a salesperson, and say an annual bonus for being the top performing salesperson in the company.
Well done, you.
Thank you. That might well be part of the normal remuneration, and I should be taken into account in calculating my holiday pay. But if everyone in the company gets a Christmas bonus, irrespective of length of service, irrespective of performance, irrespective of what job they do, that is much less likely to be included. But it is very fact specific. Difficult to set any very general rules for that.
It is, and it's a really fraught topic because obviously for some people bonuses are an enormous proportion of their salary, so they are going to argue tooth and nail that these are included, and so there's going to be a lot of sort of litigation generated just on that point, really. So we can't give any really specific guidance, but some general rules, as Iris has said, apply. So all of that only applied to the basic leave entitlement.
Just
now,
to make it complicated,
I know.
We're moving on to
Don't worry.
a different thing.
Don't worry, because additional leave is actually more straightforward. If we're looking at the 1.6 weeks of additional leave, sections 221 to 224 of the Employment Rights Act do apply with no modifications. So you don't get all the European law bells and whistles. You don't get overtime, no commission, no standby and call out, no bonuses. It's just your straightforward pay.
And that's what sections 221 to 224 say. So basically the additional leave calculation is a domestic law principle.
Exactly.
But the basic leave calculation is a European law principle. Because the European legislation, as it was before Brexit, and has remained the same because we haven't changed our rules post-Brexit to change it, says that the amount of basic leave you get has to be calculated in the way that the European case law tells us.
It's a derived right, and until we change our laws, those rules apply.
Okay, and of course, again, I keep coming back to it, but if you have contractual holiday, in other words, holiday which is above the 5.6 week basic and additional leave, then how the pay is calculated for the purposes of paying you your contractual holiday pay depends entirely on what the contract says. It's a purely contractual question.
Absolutely. We just have to look at the wording of that. So enforcement, that's probably something that most workers care more about than everything else. Under the working time regulations, you can bring a claim to the employment tribunal for one of three things or multiples, those three things. So that you haven't been allowed to take your basic or your additional leave, that you haven't been paid enough or at all for that leave, or that you haven't been paid for your accrued but untaken leave on termination. And those are all derived from Regulation 30.
Okay. And what about the remedies for those claims? They're also in Regulation 30, aren't they? Sort of further down in the regulation.
All in one helpful place.
All in Regulation 30. And where the claim is about a refusal to allow the worker to take their holiday, the remedy is a declaration of their entitlement and compensation for the lost benefit of loss of immunity of not having been able to take the holiday. for the failure to pay or underpayment or the non-payment of accrued but untaken holiday. At termination, straightforwardly, it's an order for payment of the amount of money that was underpaid.
Sure. Yeah.
And there's a new proposal, isn't there, as well, Eleanor, which you've been looking into. In the Employment Rights Bill, there is a suggestion of further enforcement structures.
There is. So if any eager beavers were present at the webinar last week, where two of our colleagues were discussing the Employment Rights Bill, they might have gone off and been inspired and done some research themselves. And if they had, they would find that there will, in theory, be a new state enforcement agency, which hasn't been given a name in the bill, but everyone thinks is going to be called the Fair Work Agency.
It sounds very cuddly.
Yeah, nice. New acronym to learn, the FWA. We don't know a huge amount about it yet. The government has just produced a little fact sheet, and the bill has some fairly vague bits to it, but some headlines. It's going to bring together existing enforcement functions that apply to things like national minimum wage, statutory sick pay, unpaid tribunal awards, and regulating the market for agency workers. But, and this is key for us, it's also going to incorporate new functions like holiday pay. So the Secretary of State is ultimately going to be in charge, and then he or she will appoint enforcement officers, and they have pretty wide-ranging abilities to investigate cases of breach. Usually it's sort of a company-wide or sector-wide level.
Rather than necessarily individual breaches.
Sure. But they will have the power to look into individual cases, and they'll have quite extensive powers to help them do so. So they'll be able to compel people to provide information. They'll be able to enter premises to search for documents, for example. And then the FWA, if it's called that, will, if it has needs to do so, take action against naughty employers. So it can issue civil penalties or order compensation, much like the current regime for national minimum wage breaches. The timescales for all this are very vague, though. The bill isn't very clear about that. So for now, tribunals are the way.
Right. So at the moment, if you want to enforce as a worker failure by an employer to allow you to take your holiday or an underpayment or non-payment of time while you're on holiday, it's the Employment Tribunal.
Absolutely.
Okay, well, let's say we are going to the tribunal, Eleanor. I know, and you know, that a big deal that troubles employees and workers an awful lot when they consider their claims to the tribunal is time limits.
The biggest deal.
The biggest deal.
Because you don't really get anywhere unless you've got that right.
No, and 3 months is not long, and which is the normal time limit. And the working time regulations are just like all the other rights that we know of, until the Employment Rights Bill is made law and possibly changes that to a 6-month time limit. For now, we are working with the time limit that we're familiar with of 3 months.
Yeah.
Regulation 30, the regulation that deals with all of this enforcement in the working time regulation, says that the claim has to be made within 3 months, either of the date when it's alleged that the holiday that should have been allowed to happen didn't happen. And if it's a longer than 1 day's holiday, 3 months from the first day that the holiday should have started.
Not the end, which does trip some people up.
Not from the end. So if you're supposed to take 2 weeks holiday, your time limit starts running from day one of that holiday that you've not been allowed to take. And if it's not a case about being refused the ability to take holiday, but it's about non-payment for holiday, which is the more common type of claim actually, then it's within 3 months of the date when your pay should have come to you with the correct full amount of pay. So that's usually your pay slip, your payroll date at the end of that month. Add 3 months. And there's the usual rules about the extension of time being the not reasonably practicable test. And there's the usual rule about a cas early conciliation extension of time. But that's it. there is just those standard extensions for not reasonably practicable and early conciliation. What there isn't in the working time regulations is any provision to link a series of underpayment or non-payment of holiday, which range across a much longer time than 3 months. So actually, if you're going to make a claim under the working time regulations about your holiday, that claim has to be submitted every time you're denied a statutory holiday or underpaid your holiday within 3 months of that happening.
Totally impractical.
Otherwise, the right to payment is lost. Totally impractical. Is that it then? Is that the end of the time limit section? Okay. Tell me
Workers
why not.
everywhere will be thrilled to hear that you can circumvent that fairly harsh rule by bringing a claim under Section 13 of the Employment Rights Act instead. So you would frame your unpaid holiday pay as a claim for unlawful deduction from wages.
Although, let me just get this right, I know it's exactly the same set of facts.
Yeah, absolutely. It's just a different legal label, which then actually has added benefits for workers. So it's good to know that you've got that other route. There was a House of Lords case called HMRC and Stringer,
Famous
which
case.
very famous. That actually is the last case we're going to throw in, so that's fine.
Thank goodness.
And that told all workers that you can use this Section 13 unlawful deductions route instead of the working time regulations route to bring a claim.
Why is that so useful?
Well,
Tell me.
if the losses go back more than 3 months, you can link those and create a series of deductions. And the 3 month time limit crucially starts to run from the last deduction. So if you've got deductions that have gone back sort of over the last year, you haven't been paid, you can link all of those and say that time should start to run from the last pay slip in which I should have been paid this holiday.
And because it's an unlawful deduction from wages claim under the Employment Rights Act, presumably you've still got your not reasonably practicable extension, you've still got your ACAS early conciliation extension, all the normal rules apply
all of
as
those
well.
normal ones apply.
Okay.
Absolutely. So there's been a lot of case law on this, right up to the Supreme Court, and I was wrong when I said that that was the last case we were going to mention, because there is another.
We just love cases, don't we?
So this is the case of Agnew, the Supreme Court's decision in the Chief Constable of the Police Service of Northern Ireland versus Agnew, to give it its full title.
And that was only last year, wasn't it?
It was only last year, but it has made a massive difference to the law in this area. It has probably created a lot more litigation than the previous set of rules, but arguably it's a lot fairer, because the position that the tribunals have to take now is if you're looking at a series of 2 or more deductions, whether that constitutes a series is a question of fact. And the tribunal can look at all the relevant circumstances when they're thinking about that. But typically they're going to be looking at similarities and differences between different deductions, the lengths of time in between those deductions, so the frequency of them, the size of them, the impact of them on the individual. So large deductions from your pay on a regular basis are more likely to be considered a series of deductions than tiny amounts which could have been in error every now and then. The tribunal will also look at the causal route for that. So how and why each of these deductions came to be made, and what, if anything, links them together.
Okay, so I get that, it's factual, you can't make any generalizations, blah, blah, blah. Okay, fine.
Yeah.
But if I give you 2 examples, tell me,
Okay.
how
I'll
you
give
think.
my view as a judge.
Yes, Judge Wheeler, tell me this. I take a holiday every year, and every single year for all the years that I've worked for this company, I've been paid less than half of what I'm owed every single time, every holiday I've taken.
Yeah.
Because they've miscalculated my massive bonuses.
Sure.
Is that likely to be a series of deductions?
I'd have said so, yes, because you've got the same type of deduction being made for the same reason every time with the same regularity. I think that there's going to be enough of a factual link, a causal matrix between those for the tribunal to think.
And it's also a large you know, the amount of deduction
Sure.
apparently is also, you'd wonder
It's
why
not,
that's relevant,
yeah.
but apparently it is relevant. Okay.
Yeah.
What about, it's going to be kind of obvious, I'm setting an agenda here. You're going to see where I'm going with this. But what about different deductions that arise from different mistakes? Sometimes my employer makes those mistakes, sometimes they don't. Some holidays I get paid correctly, some holidays I don't, and I actually don't take a lot of holiday anyway. So it's only once or twice over the last 5 years that these deductions have actually happened.
So unfortunately, gross incompetence is probably going to foil your plan to bring a successful Section 13 claim, because if your HR department is just useless and they do the calculations wrong, but for lots of different reasons all the time, but the times between them doing this are pretty varied.
And perhaps sometimes they get it right.
And sometimes it's okay. That may well break the chain and it's not going to be considered a series. So
but it is fact specific.
It is very fact specific.
So those are just those are kind of two extreme examples perhaps, but the reality of most holiday pay claims where you're arguing about whether or not something is a series of deductions are somewhere in between those two extremes.
Yeah, which is why we're in court.
Which is why you go to court. We love it.
Yeah.
Okay, so let's just recap that there used to be this rather harsh but very simple rule from the case of Bear Scotland, which has now been overturned by Agnew, which was that if you have more than a 3-month gap between deductions, it's not a series.
Yeah.
It has to be less than 3 months apart.
And
that is no longer the rule.
Yeah, I'm sure tribunals and employers loved that because it was so alluringly simple, but Agnew took the view it's probably not really fair. So all the cases have now got to be judged on their own facts.
Okay.
And a 3-month gap in between some deductions might actually break the chain and be regarded not as a series, but it's fact specific, so it might not. However, and this is a big however, there is a backstop to all of these claims under Section 13 ERA. You can only go back 2 years. So even if this egregious reduction from your holiday has been occurring for 10 years,
very regular and it's always the same,
yeah,
and it's a clear series across the 10 years.
Unfortunately, an amendment has been made to the regulations and it is only 2 years that you're allowed to go back because there was some concern about floodgates being opened for large employers who've mucked up for many years in a row, not being able to satisfy massive tribunal judgments.
And in fact, the Agnew case, which is a Northern Ireland case, where this 2-year backstop doesn't exist, was a case where the Chief Constable of the Police of Northern Ireland had
all
something
the police officers.
All the police officers in Northern Ireland, 10 years or longer's worth of underpaid holiday to sort out.
An extraordinary amount.
Extraordinary
and
amount.
So the English courts, the English legislature took the view that we should change that. So we've got a 2-year max here, doesn't apply elsewhere.
Okay, I think that's a great place to pause and see whether our keen audience has asked any questions.
We have one question here.
One brave question.
Which is, what is your view on whether holiday can be deemed carried over indefinitely / until termination under the rule in Pimlico Plumbers in the case of underpayments rather than total non-payment of leave? Okay, that is a slightly more complicated position. The overarching principle is you can't carry over indefinitely unless any of the exceptions that Iris has run through applies.
I think this is a bit of a cop-out, but the answer is it's not clear.
Yeah.
Because of the Pimlico Plumbers. Pimlico Plumbers has been a well of wonderful case law, hasn't it, as a company? All relating to fantastic arguments about various elements of worker rights, which were not granted to the plumbers of Pimlico Plumbers.
Indeed.
And one of those is carryover, because in the Pimlico Plumbers cases, people were not being paid at all, as opposed to being underpaid for holiday.
Yeah.
For what it's worth, in my view, the correct legal position is that the carryover rule applies i.e. the 1 year only carryover rule applies, irrespective of whether there's been an underpayment or a non-payment. But I'm going to just go ahead and say that if anybody's got a good case in which the point could be run,
Let's debate and let's do it.
Then let's do it, absolutely.
Yeah.
It's a good example of the complexity of holiday pay law and the difficulty of getting good answers to those questions, because each individual case is often about small amounts of money.
Yeah.
And so the claims don't tend to go anywhere. They don't tend to get appealed, and then you don't get decisions. Apart from companies like Pimlico Plumbers, where there are very large numbers of people affected by the particular decisions, then you do tend to get effort being made to get the points across and to get a good decision, or a decision that suits one side or the other. And then we end up with appeals, and we get reported cases, and then we get a chance to actually fight out these points. But it really is a point that is waiting for a further case law. At the moment, my advice is that you've got 1 year's carryover, whatever the facts.
Work on that basis and don't risk it otherwise. We do have one other question, which I think is probably a little bit too lengthy to read out and a bit too substantial for us to deal with you lot, but we will certainly respond to that via email, because it's fairly long and involved. So
yes, it's also about carryover. So I think let's look at those two questions on carryover. We'll come back to the people who've asked those questions by email. That's a good idea.
Yeah.
Excellent. All right. Well, unless any further questions come in the next minute or two, I'm going to go ahead and share with you, Eleanor, my what I was taught when I was a pupil barrister about the golden rule of advocacy.
Tell me all.
First, tell the judge what you're going to tell them.
Yeah.
Then tell them. Then tell them what you've told them.
Fantastic.
Should we do that now? Okay. So, on that note, shall we conclude and summarise? We've got to. Let's summarise the law on holiday pay on an introductory basis, as it is today, the 3rd of December, 2024.
With that caveat that it might change, because as Iris said, this is an area of law where things are cropping up all the time. So basics: employees and workers both have holiday pay rights.
And if you are not a volunteer, and if you're not genuinely self-employed, you're probably a worker. Emphasis, though, on the word probably in that sentence.
You've got some basic rights. Those are the right to take holiday, the right to be paid while you're on holiday, and the right to be paid for untaken but accrued leave when your employment contract is terminated.
And the calculation of what you are entitled to be paid when you are on holiday is complicated, especially if your hours and pay are irregular.
Absolutely. The rights that you do have are enforced at the moment by making a claim to the tribunal, but in the future, the state might enforce holiday pay via this FWA that might come into existence.
Fair Work Agency. Look out for that. And finally, individual claims for underpaid or unpaid holiday in the employment tribunal do very often end up giving rise to complicated arguments about time limits, and an awful lot of the case law is about time limits for that reason. And that's because, of course, factually, underpayments for holiday will have been made from holiday to holiday over a number of years. And that's why the time limit points come.
No, I think
that's a fair summary.
Gives you a concise summary. Thank you very much for listening. We do appreciate it. As I said at the start, this recording and the recordings for all the other webinars in this employment law series are on our website and will be circulated via email in respect of this one. Also, the recording and the supporting documents from our employment team annual event, which was all about the law relating to menopause, is online and will be available on our YouTube channel in the next few days. And finally, if you've got any feedback, we'd be very happy to hear it. So please do feel free to email that in.
If we do find there are unanswered questions, we've got those questions about carryover, and if there's anything else that has come in or does come in, we will follow that up with the people who've asked those questions by email. If you're watching this recording, not live, but watching it on the YouTube channel, and you've got any questions about what you've heard, then please do email those questions to that same email address we gave you at the beginning, events@42br.com. We will be delighted to have your questions and we will respond to them. We are also in Chambers currently putting together a programme of employment law webinars for next year. So please keep an eye out for that and join us for those webinars starting from January 2025.
Please do.
And that just leaves it for me to say thank you for watching and Merry Christmas.
Absolutely. Enjoy your
everyone.
festive period.
Bye.
Thanks.